Hello everyone, myself Bonani Deori. I'm a research scholar from University School of Law and Research, University of Science and Technology, Meghalaya. Today I'm going to give a lecture on a topic related to the paper named Environmental Studies, and the paper code is 201. And today I will discuss about National Green Tribunal, and I will start today's session with an introductory part. Then I will discuss about the National Green Tribunal, its objectives, its structure, the functions and jurisdiction of the National Green Tribunal, and along with that, strength and loopholes of the National Green Tribunal. So one of the most discussed or concerned issues of contemporary period in a global platform is environment and its protection. So we have been facing crisis of clean environment, and India is a developing country. Since a long time it has been facing or confronting environmental pollution, and the main cause of the environmental degradation is the human activities such as industrialization, urbanization, population explosion, then poverty, then overexploitation of natural resources. So these are some of the major factors which have been contributed to environmental deterioration or degradation. And in recent time, the risks to human health along with the environment degradation has also become great concern of humanity. And here, the law is an instrument or a regulator to prevent human activities which are causing the environment. So therefore, in this regard, there are various international, national, regional initiatives and development have been taking place. So one of the major steps taken by India is that India is a party to the decisions taken at Stockholm Conference 1972 and Rio de Janeiro Conference in 1992, where the state parties were asked to provide effective access to judicial and administrative proceedings, and also asked to develop national laws regarding the liability and compensation for the victims of pollution and other environmental damages. And India has already the growing trend of environmental litigation before the high courts of various states as well as the Supreme Court. And even the judicial approach is also treated the right to healthy environment as a part of the right to life under Article 21 of the Indian Constitution. Along with that, the Parliament of India has also great contribution towards environment protection because it has been enacting various environmental legislation from time to time. So one of the most important legislations in is National Environment Tribunal Act 1995, which was enacted by the Parliament to establish a National Environmental Tribunal for effective and speedy disposal of cases and to provide for strict liability for damages which are arising out of accident occurring while handling any hazardous substance. But this tribunal had very limited jurisdiction, and in fact it was not established. So after 1995, in the year 1997, another act was enacted to establish the National Environment Appellate Authority, but it had also narrow scope regarding its jurisdiction. So what happened? Due to the complex nature of environment litigations, the Supreme Court of India felt the need for establishing separate environmental courts for faster, cheaper, and more effective resolution of disputes in environmental matters. The need for establishing a separate environmental court was first highlighted in the landmark judgment of MC Mehta versus Union of India 1987, which is popularly known as Oleum gas leak case. Then again in 2001, in the case of AP Pollution Control Board versus MV Naidu, the Supreme Court requested the Law Commission of India to consider the need for constitution of a specialized environmental courts. So therefore, the Law Commission of India in its 186th report 2003 recognized the inadequacies of the existing appellate authorities constituted under various environmental laws and reviewed their position with a view to bring uniformity in their constitution and the scope of their jurisdiction. After that, the Law Commission recommended for setting of environmental courts in each state or group of states for exercising all powers of a civil court in its original jurisdiction. So, accordingly, the National Green Tribunal Bill was passed by both the House of the Parliament, and it received the assent of the President on 2nd June of 2010, and it became the National Green Tribunal Act 2010, and the act came into force on 18th of October in the year 2010, and it has its jurisdiction over civil cases, and there are three schedules in this act. So now I will discuss about the National Green Tribunal. So it is a specialized body set up under the National Green Tribunal Act 2010 for effective and expeditious disposal of cases relating to environmental protection and conservation of forest and other nature resources. And with the establishment of the National Green Tribunal, India became the third country in the world to set up specialized environmental tribunal, only after Australia and New Zealand, and the first developing country to do so. And the NGT is mandated to make disposal of applications or appeals finally within 6 months of filing of the same. And the National Green Tribunal has 5 places of sittings. New Delhi is the principal place of sitting, and the Bhopal, Pune, Kolkata, and Chennai are the other 4. Now, I will discuss about the objectives of NGT. So, there are total 5 objectives of the National Green Tribunal. So, first one is to provide effective and speedy disposal of cases relating to environment protection. Secondly, to provide for conservation of forest and other natural resources, including enforcement of any legal right relating to environment. Then thirdly, to provide for giving relief and compensation for damages to persons and property. Fourthly, to repeat the National Environmental Tribunal Act 1995 and the National Environmental Appellate Authority Act 1997. And lastly, to work towards spreading awareness about various environmental related laws and the issues prevalent in the society. So now I will discuss about the structure of the National Green Tribunal. So the tribunal comprises of the chairperson, the judicial members and expert members, and they shall hold office for time of 5 years and are not eligible for reappointment. Then the chairperson is appointed by the central government in consultation with Chief Justice of India, and a selection committee shall be formed by central government to appoint the judicial members and expert members, and there are to be at least 10 and maximum 20 full-time judicial members and expert members in the tribunal. Now, I will discuss about the functions and jurisdictions of the National Green Tribunal. So, the National Green Tribunal was constituted not only to provide for effective and speedy disposal of cases, including multidisciplinary issues relating to environment protection, and to provide effective access to judicial and administrative proceedings, but also provide redress and remedy, and to develop various national laws regarding liability and compensation for the victims of pollution and other environmental damages. So while taking decisions and pass orders, the NGT applies the principles of sustainable development, polluter pays principle, and precautionary principle. And the National Green Tribunal is not bound by either the Code of Civil Procedure 1908 or the Indian Evidence Act 1872, but works on the principle of natural justice. So, Section 4 of the National Green Tribunal Act provides for the composition of the tribunal, and we have already discussed about the structure of the National Green Tribunal. So now I will discuss about the strength of the National Green Tribunal. So, over the years, the National Green Tribunal has emerged as a critical player in environmental regulation, passing strict orders on issues ranging from pollution to deforestation to waste management. And the National Green Tribunal offers a path for the evolution of environmental jurisprudence by setting up an alternative dispute resolution mechanism. It helps reduce the burden of litigation in the higher courts on environmental matters. And the National Green Tribunal is less formal, less expensive, and faster way of resolving environment related disputes. It also plays a crucial role in curbing environment damaging activities. The chairperson and members are not eligible for reappointment, and therefore they are likely to deliver their judgments independently without any pressure. And the National Green Tribunal has been instrumental in ensuring that the environment impact assessment process is strictly observed. So these are the strengths of the National Green Tribunal. Now I will discuss about the loopholes or the reforms which are needed by the National Green Tribunal. So first one is the Ministry of Environment and the Forest has often accused the National Green Tribunal of overstepping its jurisdiction by pronouncing decisions which are beyond its scope. So one of the recent cases of conflict was with the government of Goa, wherein the National Green Tribunal had imposed a ban on sand mining in the state. The government contends that National Green Tribunal does not have a legal mandate within their jurisdiction and it does not have a right to act suo motu on certain environment related disputes. So there are increased questions that are raised on the matter of manpower hiring by the National Green Tribunal, and critics have pointed out that this method needs to be made more transparent and subject to review by various academicians, scholars, and NGOs. The National Green Tribunal has been facing difficulties in terms of the number of members appointed, and the tribunal is working with only 7 members as opposed to a minimum limit of 10 members. And the time limitation clause mentioned in section 14 clause 3 of the National Green Tribunal Act 2010 is very confusing or indistinct, and therefore it needs a change. And some analysts have also pointed out that the jurisdiction of the tribunal needs to extend, because currently the tribunal enjoys power of only few environmental legislation such as the Water Prevention and Control of Pollution Act 1974 and the 1977 Act, the Forest Conservation Act 1980, the Air Prevention and Control of Pollution Act 1981, the Environment Protection Act 1986, the Public Liability Insurance Act 1991, and the Biological Diversity Act 2002. So this means that any violations by the government relating to the provision of this acts can be only challenged before the court, and this means that relevant questions relating to the provisions of any other act cannot be challenged in front of the National Green Tribunal and certain acts such as the Wildlife Protection Act 1972 and the Indian Forest Act 1927, which are very important, they are not covered under the ambit of the tribunal. So there is a severe lack of resources with the National Green Tribunal in case of the speedy redressal of the dispute that come up before it, and there is an urgent need for a comprehensive legal framework in order to interpret various acts and provisions relating to environmental protection. So these are the loopholes of the National Green Tribunal. Now I will give a brief note on National Green Tribunal. So the National Green Tribunal is a first-track judicial body formed with the objective of addressing the issues about the environment at the national level. The National Green Tribunal has given various path-breaking judgments and directives to the authorities since its inception, including a ban on noise pollution and illegal mining, orders for wildlife protection, and the preservation of biodiversity at various places. And the way the matters were handled and justice was delivered by the National Green Tribunal demonstrates that justice is there for every common man as part of his right to life in a pollution free environment as stated in Article 21 of the Indian Constitution, and this has highlighted the necessity of the theory of public trust doctrine, which requires the government to act as a trustee of natural resources for the benefit of all people. And the establishment of the tribunal was undoubtedly a noble step in addressing the environmental disputes in Indian society. Thank you.